So welcome everybody. I'm Cassie Cresswell. I lead Illinois Families for Public Schools. I'm based in Chicago, and I'm also a co-chair of the National Group Parent Coalition for Student Privacy. And the co-presenter today will be Lainey Hameson in New York City, who is also the founder and co-chair of Parent Coalition for Student Privacy and leads Class Size Matters, grassroots advocacy group based in New York City. So for housekeeping, we're recording. We already announced that. We have, I'll go through what we're going to cover tonight. We'll start out with a little background to tell you who Parent Coalition for Student Privacy is. I'll give you some background on what we mean by this student data sale business and how it involves test vendors. Lainey will talk about how New York State has ended their data sales and how we can organize elsewhere to stop this in other states. And then we'll try to give you some tips on to protecting your own child's data to the extent that it is possible these days. As a disclaimer, we are not lawyers. Nothing in this presentation is legal advice. We're trying to inform you so you can advocate along with us on these issues. If you haven't yet, please put your state in the chat, and we have a nice array already of people here from across the country, so we'd love to hear where you are tuning in from tonight. Okay, so I'm going to turn it over for a little history of the Parent Coalition for Student Privacy from Lainey.
Okay, so FERPA was a fairly strong student privacy law that was passed by Congress in the 1970s. What it basically said is that any information in student records could not be shared outside the school and the district without parental notification and consent. But what we didn't realize is in the 2000s, there was a really very significant weakening of that law, not by Congress, but by rewriting the regulations for it by the US Department of Education. And there's a real question, outstanding question still as to whether that rewriting was legal, but we will go over that quickly. And basically under George Bush II and under Obama, they allowed schools and districts to offload and disclose student personal information to a whole range of companies, organizations, and individuals under three exceptions: school officials, audit, evaluation, and research. And school officials is the one where basically the school can call anyone a school official if they're doing a job for the school or district that the school would ordinarily do. And so that was really the biggest giveaway of all. So how did we become involved? I run an organization called Class Size Matters. I wasn't particularly involved or even interested in the student privacy issue until I learned in about 2013 that the Gates Foundation, which I have been studying for a very long time because they had imposed a lot of negative reforms on New York City. And I was reading on their website and I read that they were starting something. It wasn't called In Bloom at first, it was called the Share Learning Collaborative, but they were going to be collecting the personal student data from nine states and districts and systematizing it and then handing it off to EdTech vendors to construct their EdTech tools around the data. And of course, at that point, the Gates Foundation was absolutely convinced that this would revolutionize education. And so we started protesting this in New York. And eventually we got Diane Ravitch, who has a very wide read blog to write about it. And then I finally got a national education reporter, Stephanie Simon from Reuters, to write about this. I tried every single New York Times, Washington Post, et cetera, and they were not interested. But Stephanie Simon was a great reporter, and she actually wrote this article the day that In Bloom was launching at South by Southwest in Austin. And as soon as people realized that this thing was really happening, parents across the country were absolutely shocked, dismayed, and started like crazy organizing against it in their own states. And so within about a year, which was incredibly quick for any sort of education organizing you will ever do, every single state that had originally agreed to share their data with InBloom had pulled out. And in New York State, where we started the campaign against it, we were actually the last state to pull out, and that happened in March 2014 with the finalization of the New York State budget, where we also passed a fairly strong student privacy law at the same time called Education Law 2D. And what the Gates Foundation had actually done is somewhat of a service to parents, because parents hadn't known, teachers hadn't known, a lot of attorneys hadn't known that FERPA had been so tremendously eviscerated and weakened over the years that this was even possible. I mean, I was getting lawyers for school boards in New York State saying, you know, you shouldn't be saying these things can't be happening because it would be illegal, and they were just wrong. I actually had a meeting with Randy Weingarten, who hadn't known that it was happening either, these revisions of FERPA. Anyway, so parents around the country at the same time realized that there were a lot of other ed tech vendors that were getting our kids' data without any controls whatsoever on them. No security protections, because there were no security protections in FERPA, and very few privacy protections. And so that awareness that had built as a result of InBloom led to the passage of about 100 state student privacy laws over the next few years to fill in the gaps of FERPA. And we are still working on trying to strengthen FERPA, but it has not happened, in 50 years. And so we launched the Parent Coalition of Student Privacy because in our battles against InBloom, we had found that there was no other organization, national organization, that was focused on this issue from the parent point of view. And we got very little help from other organizations, including the ACLU and others, who we thought would be horrified at this and actually just sort of shrugged their shoulders. So we did form in July 2014. We got invited to testify before Congress twice early on. We have continued to submit comments, for example, on the recent re-regulation of COPPA, which is another federal law that the FTC is now rewriting regulations for. Occasionally, we try to help families in filing FERPA complaints or even complaints with their state. And we've done 3 reports with the collaboration of other organizations. Parent Toolkit for Student Privacy, Educator Toolkit for Student Privacy, and the State Student Privacy Report Card, which grades all states on their student privacy laws. And these are all available for free on our website.
So now I'm gonna give some basic background information on basically this student data sale business and why it involves these standardized testing companies. So just to give you sort of like a little graphic overview, where does the data come from? Who's buying it? It starts with students who are taking mostly college admissions tests or advanced placement tests. And before they take those tests, they complete a survey. So that's where a lot of the data comes from. Then the test vendors use the survey to populate a database. And that's basically the raw material then that they can sell to university admissions offices, which then buy some subset of that data that's filtered by who they are wanting to recruit to apply and enroll. And so this is often called a student list or names that they're buying.
Sometimes they want them to apply, but not necessarily to accept them, but to raise their rejection rate.
So the test vendors then also have access to other data, and that becomes another product that the admissions offices can pay for. Basically, the use of software services where this survey data is combined with other data sources. And in some cases, there's basically like third-party consultant companies that are really the admissions offices are working with to access this other data. So what kind of data is being sold? really a long list of things. So I just pulled this list from one of the College Board's like many websites. Big Future is one that's sort of kind of like place to go to look for scholarships and where they're sending students to. So they disclose a list that they say that they're sharing. So name, address, gender, date of birth, really a whole long list of things here. You see religious interest, colleges that you're interested in. And so this list is a minimum. We don't know if really there is other things as well. And so two things to note here, something as simple as an address actually is really a lot more complex than that. Your home address will tell you a lot of demographic information about you, potentially like, the basic, like the income level of your neighborhood. And another thing really to note here is that your test scores are being shared. Colleges will buy a range of students in a range of test scores. So like give us everyone who has between a 700 and a 730 on the math SAT. And so even if you are applying test optional as a student, the colleges will know your test score within like a range anyway. So I think that's something that is not generally recognized about the data that's being sold. So how much does it cost to buy this data? Anywhere from $2,500 to buy several thousand names to basically more than 500,000 names or an unlimited set of names with a bunch of extra services. You can pay the College Board this year $540,000 for that. Pre-pandemic, the College Board was making about $100 million per year. That was probably cut into a bit because of this push for test optional. ACT Inc. is not as forthcoming with information about how much their pricing is. So it's a lot harder to know how much they're charging these days. And their data sales business is really through something called Encura. So you can see a lot about the services they provide, but it's not really clear what they're charging clients.
But
So,
Cassie, can you go back to the thing about parent contacts that I highlighted?
yeah, so something here on the sales thing, an interesting thing to note is that if you pay them a little more, you can also get contact information for parents, which is also not something that's clear, when you're a student filling out one of these surveys, among many things that are not clear from when you fill out that survey information. So why are colleges buying this? It makes their recruiting more efficient. They can find, give us a big list of students in Idaho, give us a big list of students who play lacrosse. There's also the data from College Board and ACT is available early in a student cycle. So kids start taking these tests in 9th and 10th grade, and you can already buy their data then. And it's also a lot cleaner than what you might get from some more generic data broker. So it's a lot more complete and it's also more accurate. So the thing is, these admissions offices can also buy additional data or these third parties that they're contracting with. And then you can combine the very clean, complete data from College Board or ACT Inc. with these messier databases, but that have a lot of information, say what websites you're going to, and your web history. Now there's also not just College Board and ACT, but also ed tech software companies that are really getting into this same business and monetizing their access to student data, either through targeted ads inside their products or also giving colleges and universities and enrollment planning companies access to the actual data about the students directly. So this sounds all really terrible, and you're like, my God, how has this been happening for years? College or the College Board and ACT Inc. market it as saying this is a win for colleges because they can find students, and it's a win for students because then they are finding out about colleges and universities that they wouldn't have otherwise heard from, and about scholarship opportunities as well. So in fact, those benefits are really exaggerated. For one thing, a lot of the research that these claims are based on is done by organizations who are profiting from the whole thing. And even looking at their actual research, the effects of this, signing up for the student search service is very small. And it's not really affecting broad college enrollment patterns. It's not really doing some sort of real change to college access. It's sort of at this very micro level of like, oh, you're going to apply for college X instead of college Y because you got a brochure in the mail from college X who bought your data. Unfortunately, the drawbacks are much more significant. There's really no transparency on the student side, even for public institutions that you're applying to. You don't really know what data they're using and where they're getting it and how they're using it. There's a lot of potential, and not just potential, but likely discrimination happening on the basis of class, race, test scores, because colleges are choosing who to recruit based on these demographic factors. So an example of this is if you're a public university, you want to find out-of-state students who are going to pay full tuition and pay out-of-state tuition to boost your bottom line, then you'll recruit wealthy students from out of state. It's, as Lainey was mentioning, it's not necessarily done to expand access, it's to improve the selectivity of a college. You can raise your ranking by looking more selective, and you look more selective by having more people apply while you're still letting in the same number. And so that's called recruiting to reject, and that's definitely what some of this data is being used for. And it's really, ultimately, it's commercial exploitation of data that is being collected from school students in a school setting, and it's really not being used for an educational purpose. And now, as we're going to talk about much more as we go on tonight, it's now illegal in many states. So how did this happen? The basic, just going from unethical to now illegal. The data has been being sold for decades. So College Board and ACT Inc. began selling these names of student lists in the early 70s. Then in about 20 years ago, with No Child Left Behind, the federal government began requiring testing in elementary school and high school for accountability purposes. So some states, to sort of, make especially the high school tests more palatable to high school students, started giving the college admissions test as their high school accountability test. So instead of paying the College Board and going on a Saturday sometime, maybe not at your own school, to take the test, now it was given during the school day. So that means the scores and the surveys are subject to FERPA and another federal law, for example, and maybe some state school student records acts. So different than when you're taking it on your own and paying privately to take it. And then, as Lainey explained before, with all these state student privacy laws that began getting passed in around 2014, there were new prohibitions on selling student data. So if that data is being collected during the school day, under basically the auspices of the school saying, do this activity, that selling that data is not permitted. As those laws began to be passed, the College Board and some other lobbyists began, going around the country trying to push for exceptions. So, they still, College Board and ACT claim that they're not selling data, they're licensing it. But the truth is they know they're selling it, and that's why they had to lobby around the country to get exceptions to prohibitions on data sales. And they did successfully do that. In some states, we'll give a list of, where there's still sales barred and where there's exceptions for College Board and other test vendors. For the most part, though, even where you have these strong state laws, they're not being enforced. That's mostly because they don't have a private right of action where you can sue if your data is sold or if the other parts of the law are violated. And instead, they're depending on state AGs, attorney generals, to enforce. So I'm going to turn it over to Lainey to talk about what that means and how that's worked out in New York State and what we can do elsewhere.
So, as I mentioned earlier, in 2014, a fairly strong law was passed in New York State called Ed Law 2D, which, among other things, completely barred the sale of student data by school vendors or its use for commercial or marketing purposes. And I soon discovered that College Board was still selling student data. Can we have all the bullet points, Cassie? So one of the things we did is I met at a meeting the chief privacy officer at that time of the U.S. Department of Education, and I brought that complaint to him. I also complained, endlessly to the New York City Department of Education and the State Education Department with no avail. But after I did complain to the chief privacy officer at that time, they did put out guidance in 2018 pointing out that the College Board, when they are acting as school or district vendors and asking kids to take these tests in schools, that it is illegal for them to sell this data, according to FERPA. It is also illegal for them to collect all sorts of sensitive information that is regulated by a separate federal law called PPRA, where you're not supposed to ask about things like religion and income and other sensitive issues, but they continued to do that as well. And so this is why Cassie said originally that when kids are taking these tests in school or out of school, there's a whole pile of survey questions that they are asked beforehand, which often the College Board does not make clear are voluntary questions about their interests, their family's income level, et cetera, et cetera. We used to hear about this because they used to ask Social Security numbers. And so kids would come home and say, Mom, what's my Social Security number? And, we were shocked about that, but they stopped doing that. But they still ask a lot of very sensitive questions, which violates PPRA without parental consent, and they continue to sell the data. And then other things happened. The New York Times wrote a big article about how the College Board had sold the data to somebody we don't know, who had then resold it to this company that markets these really expensive summer programs for students for thousands of dollars that say that, they will help you get into college, and were completely worthless and very, very exploitative. And then we also, between 2014 and 2018, had been pressing the state education department to finally write regulations that would allow them to enact the law that was passed 4 years ago. And they finally put out regulations. The first draft were not strong enough, but they were better than nothing. And then, and I was appointed to a data privacy advisory board by the state. And so we were giving input on the regulations and what they should look like. And then, unbeknownst to us, they put out a second round of regulations where they completely eviscerated them and created a loophole for the College Board. And at that point, I went completely nuts because I said, not only were these regulations immoral, but they would violate the law itself, which basically said no sale of student data, no matter what, and by school vendors. And so I ended up writing a piece for the Washington Post about this because I was so frustrated. And then shortly thereafter, our state regents, chancellor, and commissioner set up a meeting for me and another advocate with the College Board and representatives from the state university system and the private colleges. And we had it out for about 2 hours in Albany and debating this, and we won the debate. And luckily, the woman who was then the chancellor and is now the commissioner of education, Betty Rosa, decided that we were right and the College Board was wrong. The College Board kept on claiming that they were doing this for charitable reasons, to extend opportunities to underserved students. And I said, okay, if that's true, then number one, ask for parent consent. Number two, explain exactly who you sell the data to, which they refuse to do to this day. And number three, do it for free. don't do it to make millions of dollars. And they refused to do that. So that was the end of that conversation. But the sale went on anyway, even though we had won this battle in the regulations and in the law. We put up a petition to the state attorney general, who is the ultimate decision maker on enforcing state law, because as Cassie said, there's no private right of action. That didn't get anywhere, even though we got hundreds of signatures. Finally, a friend of mine or someone I knew casually joined the AG staff, took a leave from her law school position, Zephyr Teachat, who'd actually run for AG and also run for governor. And she set up a meeting with me with the AG staff, and they started negotiating with the College Board over this. We had a meeting in the summer of 22, and then some point thereafter, they started the negotiations. Zephyr had to leave the AG's office, but then I finally heard, actually on February 14th, Valentine's Day of this year, that they finally finished the negotiations and they'd gotten the College Board to sign a consent decree that they would stop selling this data and they would be fined $750,000, which is not a lot of money when you actually look at the hundreds of millions of dollars that they had made illegally over the last decade by doing this. But anyway, that was a big victory that we got this decision. So next slide. So we have looked at all the states that, like New York, bar the sale of student data by school vendors with or without parental consent, as in New York. Are going to share that spreadsheet with you and the map so that you know whether you live in one of those states where it should be stopped just the way it was stopped. What you can do is to see facts that your district or your state has with either the College Board. States have these contracts, sometimes the districts for AP test, et cetera, et cetera. And you should look over those contracts to make sure that they prohibit the sale, rental, or license of students. Even if you do not live in one of these, you should add that. And really dishonestly done in order to fight back is that they have asked students to make their own accounts with the College Board, with or without the knowledge of their parents, and then sometimes sign these disclaimers saying it's up to the student to know whether this violates state law or not, which is really outrageous. And of course, most of these students and we also believe that even if you do not have a state law that bars this, we still believe that it's maybe illegal under FERPA for the sale of this student data, as that guidance document mentioned that I cited earlier, and we'll get to that again. Next slide. So these are the 20 states where no student data sales are allowed. Again, this is only when the College Board or ACT is giving the test in schools, acting as a school vendor. If your child is taking these tests outside of school on the weekends or whatever, none of these state laws or FERPA or any of federal laws hold. They only regulate the behavior of schools and districts. So that's something to keep in mind as well. But if your state is on the list, you should be advocating with your attorney general to get them to do the same thing that the attorney general has done in New York State. Next slide. And these are 12 states where the College Board has successfully law or in an amendment to the law to create a special exception for the College Board and ACT for the called national assessment companies generally, with parent or student consent. Again, student consent is really creepy and probably illegal because in state law and in federal law, students under 18 are not considered adults in order to sign away their rights. District of Columbia, you see there are 2 asterisks there. So only students over 13 may consent. I don't know why that is, but it probably has something to do with COPPA. And Maine is the only one of these states that actually says parent or students over 18 and has done this in what I consider a semi-legal way. And then Utah, Virginia, they, I think, basis for the sale of student data, and neither by or by. So here are some steps that you can take. Check out your state law. We're going to share the spreadsheet, and maybe at the end of it, Cassie, you can give us a quick look at this. Take a look at it yourself. Out your contract again. They online in states, or you file a information request. This only but of course, PTs, I think, are almost uniformly done during the school day. Go on. Find other concerned families if you organizations to sign up, or just handle yourself. Do an online petition. Call petition your attorney general and your state and local education officials. And these are things they should be. And so every single district, whether or not you have a state law, could have this in their contract, have this data without consent. And students over 18, but not students under 18. And we have a template for a letter to your state attorney general that you can use, that has a place that you can fill in the number of your state law, the name of your state, et cetera, et cetera. And we have other sample letters. Do we have other sample letters?
We have examples of letters, especially here in Illinois and maybe from New York, where we have sent them to other like.
Yeah, well, I don't know that we have them now, but we'll make one and then we'll send it to the link to everyone who's registered for this. Basically, we've sort of tried to make this as by researching law. If you go to the spreadsheet, you will have the number, you will have the link, you can go read it yourself. And then all you'll have to do is enter in your state attorney general's name and email address and start working at this as soon as possible. And of course, we say in the letter that New York aren't. Next slide. And then this is my other pitch, which is that even if you live in one of the 30 states or something that was a little bit, it still violates FERPA. And this is a quote from the 2018 guidance of the U.S. Department of Education, which we can quote. They talk about the 3 exceptions of FERPA: the audit evaluation, the study, the school official exceptions. But then this guidance clearly says, quote, under all 3 of these exceptions to consent, the testing companies would generally be prohibited from redisclosing PII from students' education records under FERPA and IDEA, which is another law for special education students that to protect their privacy. Prohibited from redisclosing the personally identifiable information without the prior written consent of the parent or eligible student, that is a student over 18. And if you're interested, we will help you file a FERPA complaint. But we want to get as many parents activated on this issue, no matter what your state is, because we really believe that this is an unethical practice that needs to stop.
So I'm going to cover very briefly things you can do, not so much as advocacy, but just as ways to protect your own child's data. So these are not foolproof, but they're some steps you can take at least. So for one, if you have a high school age child, they can not complete the optional survey before they take the ACT or the SAT or any of these pre-ACT or PSAT tests. And there's even surveys that are given before the advanced placement tests as well. These do not necessarily happen on exam day anymore. They might happen a couple days before the test when there's a sort of a digital readiness check. So let your child know about that this is optional. There's a little bit of information that you essentially have to provide, like name, date of birth, gender, address, sometimes a student ID number or a state student ID number. But really you do not have to answer any of those other questions. This is not something that's necessarily made clear to students at all when they're taking the exam. Lots of times now schools have kids create an online account, especially with collegeboard.org, in order to access their scores. So this may happen really at any time. Try to let your child know about this taking place. You could, if they're doing it at home, you can sit with them as they're doing it in order to see, you know, what rights they're signing away as they create this account. And in particular for College Board, you don't want to agree to sign up for the student search service, and you don't want to sign up for the Big Future School mobile app. You don't want to sign up for the student search service through the bigfuture.collegeboard.org. So there's a bunch of different kind of interconnecting sites and many opportunities to basically agree to give your data away. ACT Inc., the similar service is called the Educational Opportunity Service. And on top of these test vendor-based things, there's also online search sites. That information is mostly being sold as well. The truth is, if you are searching for colleges and universities, if you want to be contacted by them, you can directly contact them and say, please send me information. I am interested in you. There's lots of places to research scholarships and colleges and universities that don't necessarily ask for you to provide them with additional data. And so in addition, if you've already opted in, you can still opt out. We'll put when we share the slides with you, you'll have this link to the College Board opt-out page. The truth is, though, this student data market is much bigger than just test vendors. And, you know, all of us are leaving digital trails all over the place all the time that are likely being tracked and resold. So anytime you're interacting with a college university website, they're going to be tracking that probably by your IP address. There's lots of sites and services that are in use in schools like Naviance that are collecting data and sharing it in various ways. And there's not really a foolproof thing here. Even, you know, opting out of the student search service or the educational opportunity service does not necessarily end what's happening. So, you know, this is really a systemic issue. We need to work on it by, you know, enforcing existing laws and contracts, making sure new contracts don't permit sales, advocating to strengthen things like FERPA, and this project to try to get at least these test vendors that are getting lots of money through state and district contracts to obey state laws that have now been on the books for a decade is really just an initial step to try to rein in this student data market. So one quick action that you can do right now, you can, if you're an Illinois person on the call, please email the Illinois AG. I'll put the link in the chat. We'll be sharing this template letter. It's not such a quick action because you have to fill in some things if you are in another state. And so now we have time for like 15 minutes of questions. And we're going to share these. So you'll have the spreadsheet of the state laws. You'll have a template to write your own AG if you're in a state with a law on the books now. And we have lots of resources for looking into the student data business. And also there's been tons of publicity and media coverage of these data sales, and yet they are still happening. So I'll stop sharing and I'll put some links in the chat for people.